Welcome to episode 18 of Quadocast, entitled The Root of All Legal Revisited. What is being revisited is episode 4, which was taken down due to privacy complaint, which was published January 8th, and it was called The Root of All Legal. Though the complaint centered around a public record, which I have the free speech right to report on, there was a more restrictive policy to YouTube that I was not aware of. There was about 5 seconds of video that revealed a little too much information, which has now been redacted, as this video will include the original episode 4 with the redaction in its entirety. The main point of the video is that all associations desperately need policy reform when it comes to the communication between the board and the attorney. The policy suggestions in this video are really years in the making, with the common theme of too much centralization of power, particularly by a president of the association. What made episode 4 notable was the discovery of old information hiding in plain sight in one of the associations that might serve as a real case scenario that demonstrates the very limits of the policy that's been crippling us here. Frankly speaking, in hindsight, the video is nothing short of prescient. What has happened since the Association of Britannia did seek a legal opinion to get clarity on their governing docs, and had received that opinion that all the Britannia unit owners had paid for, yet none of the Britannia unit owners are allowed to see, according to their president, without any basis for keeping it confidential. It is the president that is ironically likely to be the most affected by the opinion. I will reserve my commentary on this for another time. Without further ado, I present to you episode 4, The Root of All Legal, redacted, originally published January 8th. Welcome everyone to episode 4 of Quadocast, entitled The Root of All Legal. As I reflect upon my 15 years living here, it becomes obvious that the root cause of most of our problems across all associations is the relationship the board has with the attorneys. What little policy, if you could even call it that, is so flawed, we are all being hurt by it over and over again in so many different ways. The community needs to stand up and let those on the board and those running for the board know one simple thing, that the policy here must change regarding this. Our flawed policies end this election cycle. So let's take a look at the current policy so you can better appreciate what's wrong and what needs to change now. So the first part of policy is the only thing I do agree with, which is when a board needs to ask legal questions from the attorney, that there's a system in place to avoid duplicative costs. You can't have too many cooks in the kitchen, so typically a president is the single point that communicates with the attorneys. However, I differ in that most of those communications should be carbon copied to the whole board. Now, there might be limited exceptions to that, which we'll worry about later. I'm talking about the lion's share of policy generally speaking, in the normal, ordinary course of business. Now, I have no knowledge of how boards filter and funnel their questions to the president, whether they are slowly pooling it from time to time and batching it, whether a consensus is that maybe some questions are moot or unnecessary or have been answered before. That I'm going to stay out of for now, other than there should be some reasonable minimum pooling process, because again, this is about reducing costs. The problem I have is everything that happens after. When the attorney replies, the attorney should reply to the whole board. It was not an accident episode 1 when I said all board members are equal, but some board members are more equal than others. One way some board members are more equal than others is when they form legal committees, which have almost no function or purpose. There could be instances and purposes for a committee in very narrow and limited ways. Otherwise, it just leads to abuse and even coercion in some cases. It's precisely what creates an inner and outer board. Again, what I'm proposing is most of the time, this is not one size fits all, and I definitely do not have all the answers, and maybe us collectively might not have all the answers, but we could certainly have the lawyers help us to have better policy that we deserve. Simply put, legal committees are misused and they do more harm than good. It creates a power structure and hierarchy within the board itself, which is where most of our problems start from. Legal committees, more often than not, are formed because of distrust amongst board members. And though that mistrust might be well-founded, a legal committee is not a solution for it. The distrust is usually specific, where some board members don't trust that other board members would keep confidentiality. I'm a believer that a board is its own contemplative body, and comes with it is a degree of confidentiality. If there's a provable offense of the breach of confidentiality, okay, well then come up with some rule, a fine perhaps. But at the same time, there also needs to be a whistleblower exception, as there have been plenty of instances where board members are holding on to something that's no longer confidential and obstructing and interfering by not releasing it. Some board members believe their power comes from monopolizing information that they have no right to. If we look at our community from a knowledge and information point of view, we have the right to access so much official records from the association, probably like 95% of it. Ultimately, anything dealing with the operation, the association in any way, we have a right to. There are some exceptions, and those exceptions are one of the differences between the community and the board. When it comes to matters of personnel and a portion of legal, the portion that might be dealing with litigation or contemplating the possibility of litigation. But this community has the right to the legal answers pertaining particularly to our governing documents. That's not confidential. In fact, it's precisely those legal opinions that help us to have institutional memory here. There should be a legal opinion folder on every association website because most of those legal opinions apply to the operation of association. We are entitled to it. It is not confidential, but none of us are doing that, and we have institutional amnesia because of it. We are all hurt by this in the long run. It's costing each of us more. All right, so let's take a look at real-life examples of how we've been hurt by it. I'll start with my own experience. In the 15 years that I've lived here, I've received 3 cease and desist letters from rogue presidents. Not boards, because the boards had no knowledge. It was never voted on. In each case, a rogue president who had the sole capacity to speak to the lawyer in confidence in private made a unilateral decision without the knowledge of the board. And fun fact, in all 3 of those instances when they ran for re-election, they got thrown out on their ass because of it. In all cases, it was unfounded and an abuse of power. I'm currently in the middle of a more recent experience that has been playing out behind the scenes for near 2 months now with recreation. I put in a simple request about a clarity of 2 points in our governing documents. One of the points dealt with all the board members of all the associations, and the office was being blocked by some members of the legal committee from being able to transmit that and forward that message. And to continue, when I had further communications, the office was even blocked from sending it to the other board members. I want to be clear, it was not the entire legal committee. This is really about 2 board members in rec that are interfering with the operation of the association. And I will get into that in more detail in another episode. One last thing on this. I then reached out direct and reached to most of the board of governors across most of the associations to go direct with it. No one stepped up. I got a call or 2 in private at most. No one replied via email. No one took it up. No one is championing what is wrong around here. And even though on one level the request was small stuff, it demonstrates the symptoms of major problems here underneath and why our governance is so piss poor and why it's going to stop this election cycle. This is just a recent example of my experience, but none of this is new. This has been going on for other people. Think about that one website shut down years ago. They didn't want to bother dealing with the bullshit nature of it. Again, it was abuse of power years ago. This has happened against, I think, an election 2 years ago. There's someone running for the board who also got a cease and desist because they didn't like what an opponent said. And when this is the norm of our culture and a few people on the board understand that they could concentrate so much more power because of lack of any real policy that protects us all, that allows the rest of the board to serve as a check and balance to their own body. That's what this is about. There are so many others that could weigh in on this of past examples that have been ongoing for years, and they're welcome to step up if they wish to. But let's make this more interesting. Let's get into a real life example that hasn't happened yet, or actually it's going to start right here, right now, in public, so we could all see together how it will unfold in the next couple days or weeks. The system's so broken, why should I bother anymore? Let me take it direct to you. Britannia made an amendment in March of 1986. Part of that amendment reads, only one spouse from the same family shall be eligible to serve on the Board of Governors concurrently. Well, according to Broward County Public Records, 2 of the board members are married, Lewis and Raoul. Lewis the president. On the face of it, it appears contrary to the 1986 Britannia Amendment, and on the face of it, one of those 2 board members should resign right now. Has this ever been addressed by Britannia before? Have no idea. Maybe it is is old news? If so, there certainly would be a legal opinion on it. Yeah, where is that? So let's say neither are willing to step down. They want to investigate it, challenge it. Well, let's see. The President of Britannia is the sole communicator to the attorney on this issue. Shouldn't they both recuse? Maybe it's another board member that speaks to the attorney. Maybe it's the office manager is a disinterested party that get the facts. And when you did, where would it go? Would the whole board see it? Would the community see it? Would it get posted? Would it get published? It's not about litigation. There's no reason why it would be confidential. And what does that look like going forward? There's an upcoming election. What if they both decide to run again? That certainly would be an issue right now. Another factor is there's something missing called Kaufman language. That usually reads as amended from time to time, which many condo associations have added since a court ruling. Upon a quick glance at other Britannia amendments and documents, there doesn't appear to be any such language. The lack of such language puts so much more weight on these amendments in the bylaws that they might prevail when Florida statute is silent on a given issue. So I guess we'll together find out and wait and see what this looks like, where it goes, what their procedures are to resolve it, whether it does become information to the community, whether the Kaufman language is examined or not. Even if the association attorney twists like a pretzel to construct an opinion favorable to them, would you really want to vote families or entire households onto the board together when such vote could always have them one vote away from majority? In my view, you want better outcomes here, you get distributed power, you get good policy, and that's how you get better governance. All of us must stand up and demand that this stop. We must bring an end to the formation of inner boards that use legal committees as a pretense to create a hierarchy and pecking order around here. And you wonder why line items and legal budgets keep going up year after year? No, it's not about the bad, sad world around us. We're doing it to ourselves. That's in part why the legal budgets are going, because of the insularity of people in control wanting to have a monopoly on information and squeezing other people out because they don't know how to govern any other way. They don't have any experience. But what else would you expect when you let control freaks run amok? Okay, with that said, this brings us to the end of The Root of All Legal. Wishing everyone a wonderful day ahead.